Welcome to Books of Our Time, produced by the Massachusetts School of Law and seen nationwide. Today we shall discuss a recent book about the moral failures of the legal system. The book is entitled The Myth of Moral Justice: Why Our Legal System Fails to Do What's Right. Its author is Thane Rosenbaum. Professor Rosenbaum is here with me today to discuss his work, and I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Thane, thank you for coming up from New York today.
Thank you, Dean.
Thane, let me start by asking a question relating to your family background. I have read in an article about you in your book that your father was a lawyer in Poland and indeed was in and survived the death camps.
That's true.
And did this have an effect? I gather this did have an effect on your view of the morality of legal systems.
Well, that and the fact that my father never practiced after the Holocaust. He had given up on his profession and moved to the United States, and in many ways felt betrayed by the law and the legal system and what lawyers and judges would do in the name of legal versus moral justice. So I suspect on some levels the decision to reclaim his job, his profession, and becoming a lawyer, and even more directly writing a book that is essentially a moral critique of the legal system, probably has something to do with that family legacy.
Yeah. Did you, when you were a boy, did you and your father discuss these things? Were these staples, for example, of dinner table conversation or other conversation?
Too emotionally loaded, I think.
Emotionally loaded.
I felt that this was something he didn't want to discuss. Certainly not the Holocaust-related experience. I knew that he had been an attorney in Poland. I knew that he'd been educated in Germany. And I knew actually when I first saw the film Judgment at Nuremberg, I started to really think about that, because as you know, the perspective of that film is the prosecution against the judges for carrying out the policies of the Nazi regime.
It's what they call, if I remember correctly, positive law as opposed to a more moral form of law.
Right. I mean, positive law is essentially carrying out what the law is rather than its aspiration, what it ought to be.
Yeah, yeah. Now, I frankly admit to people that in my life, I have been involved in a couple of major cases among the other legal work that I did. And they went far to shape my own view of the law and the legal system, which is not a particularly positive view of it. I say that because I gather that you have had some personal experience with the legal system, and that had some impact on your own views of the way the law operates and the way it should operate.
Well, Dean, most people who have any experience in courtrooms or involved in legal proceedings in America walk away embittered. Even winners, even technically the winners, walk away ambivalent. And I think that says a great deal about the absence of a kind of true moral resolution that we provide in America. The very fact that most people walk away embittered, resentful, betrayed, feeling as if they've been unheard, feeling as if they never had a day in court, feeling as if no one would listen to them, feeling as if they've been interrupted and dismissed and disacknowledged from whatever grievance brought them. And I too, on a personal level, although I am a law professor, I'm not unmindful to what happens in courtrooms. And no doubt those experiences of feeling dismissed and disacknowledged in some ways resulted in the writing of this book and some of the courses that I teach.
Thane, I'm sure that people in the audience would not find it hard to understand why somebody who's lost a legal case would feel embittered, dismissed, not listened to, and the other words that you used. Less immediately comprehensible, perhaps, would be that winners feel the same way. What is it about the legal system, in your judgment, that causes winners, too, to walk away with these bad feelings about the experience they've been through?
Well, as I point out in my book, Dean, the American legal system, under its conventional paradigm, is really only interested in a kind of winner-take-all struggle, where in a zero-sum adversarial contest, we deem one side the winner, and we reward them only in material terms. In the criminal area, we put people to jail, and in the civil area, we give them a check, we give them some money. And as I point out in the book, moral justice, moral relief, moral remedies require also a spiritual dimension. What oftentimes drives lawsuits is not the material loss, but it's the insult that was added to the injury. So much spiritual violence, so much neglect, so much indignity, so much grievance is what drives the legal complaint. Judges and lawyers convert them into conventional, concrete cases. But the indignity always persists, the sense that just because I received money on this day doesn't make me feel as if the injustice or the betrayal or the breach will go away. There's a false closure to final judgments. They may be final for legal purposes, but emotionally they're wide open. People can exhaust years, not just in money, but in emotion, trying to vindicate a claim. And at the end, they receive money and nothing else.
Thane, let me go back to, let's examine various aspects of what you just said, because it was a mouthful. Judges' opinions are regarded widely as a statement of the actual facts of the matter. Do you think that is true? And if not, what is the effect of that, in your terms, on both the winner and the loser?
It's a great question. I mean, people who go to law school know that there's a huge difference between legal facts and literal truths.
I don't think people who go to law school do know that.
Well, I think people must graduate, must at some point
after
figure
they
it. Right,
graduate and
right.
get in
No,
practice,
I think you're quite right, Dean. I think that's the problem. The discontinuity between the belief outside the law that the law should be or is fundamentally moral, and that the law is principally interested in discovering truths. Lawyers and judges know that truth has nothing to do with the outcome of a legal case. Nobody's interested in the truth. They find facts. Those facts oftentimes have no relationship to the truth. And the party against whom the facts are found walks away outraged, thinking that now this is deemed the record of what took place, knowing full well, even the lawyers might know full well, that it's not in fact true. And there's no truth to the facts that have been found. So this presumption of legal facts as meaning something other than a way to resolve the dispute in court, but have no bearing on actually speaking to a truth. Both parties know this. The losing party is completely outraged by it, and yet the official record of the proceedings suggests something that is ultimately untrue, but for legal purposes is deemed found, whatever that means.
Right, and in simple ABC terms, the court says the facts are A, B, C, and D, whereas somebody more interested in the truth might say, well, there are various reasons for thinking it's A, but there are various reasons for thinking it's counter A. And the same with B.
Or A is simply not true,
Yeah.
that it was found to be A is true. But even both lawyers know that it's not true, but the jury blew it. The jury was confused, or the truth was trivialized, or...
Thane, this is a little bit off, that's not off the subject of your book, but it's new. There's been a program recently on ABC called In the Jury Room. Mm-hmm. Have you had a chance to see that at all?
Yeah. Mm-hmm.
Well, my own reactions to it, and that of my wife, and I'm interested in your reactions, were twofold, threefold. First, that the lawyers were terrible in general. Second, that the jury often was terrible.
Right.
And third, and I really find this greatly distressing, many times the people who favored innocence were the female members of the jury, and and my wife agrees with this, so it's not some kind of white man machoism. Almost invariably, those ladies collapsed in the face of opposition by the men. Do you have, and the people were convicted, do you have any view at all on what that program showed in any of these regards?
Well, it's interesting, I think you can go back to dramatic film and remember 12 Angry Men, the play and the Sidney Lumet film, I think is another example of the impulse towards guilt. And remember, there are no women in that jury room. Right. And a kind of sense that you're putting your life in the hands of 12 people who want to go home.
Yeah.
That they have other things. One of them had baseball tickets to a Yankee game.
Yeah, right.
And so the idea that justice depends on a sense of justness of people, goodwill and kindness, and a sense of true civic responsibility, That and the fact that I think that what that show also shows is not just that the lawyers are terrible, but that the jury is inadequate to find truths because what they've been presented with are falsehoods. That what we do is we send so many obstacles in trials. We trivialize and distort and twist and fudge and spin to the point that truth is meaningless. And in an adversarial system, we then ask the jury, knowing full well we've confused them, to find facts.
Why do you make a big point, Thane, out of the concept of relevance and the judge insisting that the lawyers in their questions and the witnesses in their answers stick to the concept of the legally relevant. You make a big point of saying that this is one of the major problems that leads to grievance, a sense that the truth hasn't been told and so forth, and seems to me, to be of the essence of what you've just been saying. Explain that.
I'm opposed to most evidence rules.
All right.
I mean, almost all of them. I think they're horrible. I think that they serve the interest of legal justice, but they defeat the larger purposes of moral justice. Moral justice provides a forum, an open forum, where people have an opportunity to come and speak in front of a community with a jury present, and to have a true meaningful encounter with the people who have harmed them. A true day in court, not where there's endless objections on relevancy and credibility, not where there's exclusionary rules where many pieces of evidence are not allowed in. It's my view from the perspective of moral justice, the more of the story that gets in, the better. Even if it makes it harder to determine a legal truth, a moral and emotional truth will be satisfied because the party will feel.
Why does it make it harder? I can understand why it would make it more time-consuming.
Well, that's what I mean.
Oh, okay.
Judges hate it because they're looking to maximize the court administration, the efficiency of moving cases along. And essentially, that's what our legal system has become. It's a factory. Yeah. How quickly can we resolve the docket and move on to the next case? Yeah. Bang the gavel and say, next case.
Yeah.
But that's not what people come for. People come for judgment and the opportunity to speak to what had happened to them.
Why don't you tell people the story about Woody Allen, because that was one of the examples you used to make this point.
Well, there's the absurdity of this case in New York where, I don't know if people remember, a number of years ago, not many years ago, maybe 3 or 4 years ago, Woody Allen was forced to sue his former business partners for whatever his claimed financial irregularities.
Yeah. He spends a lot of time in court on one thing and another.
Absolutely. But these former business partners were also among his best friends. And I also talk about in the book how difficult that is. It's very hard emotionally to sue your friends. And you don't see it often, and when it happens, it's ultimately destructive, ruinous. There's no way to recover from that. But in the case, under direct examination, his attorney, Woody Allen's attorney, asked him open questions, and Woody, not untypically,
what do you mean by an open question?
Meaning that questions, how did you learn about these people? When did you first meet these people? At what point in time did you learn that the films weren't doing as well? And Woody Allen strayed in his responses. He's a filmmaker and a writer and a comedian, and he was also very agitated and nervous, and spoke openly about various things that were deemed by the judge to be off the topic, not relevant to a concise reply. And so at one point the judge just took over and answered for him. And he would say, the answer to that is yes. The answer to that is no. Yeah. And I think, if you read the transcript, it was clear that Woody Allen was dumbfounded that he wasn't being given an opportunity to speak about something.
Would it be fair to say, Thane, that in our everyday conversation, we tend to elaborate, to embellish, we have a lot of verbal curlicues, instead of going straight to the point and saying, the short answer is yes.
But so what? Yeah. What's wrong? Why do we need these short answers? Yeah. I mean, for only on the one reason, to get it over with. But if you recognize from a moral justice perspective that people come to courtrooms not just to reclaim money, but to reclaim their dignity, their pride, something's been taken away from them. It's not always financial. That if judges and lawyers could understand that, again, the perspective of moral justice, of giving people an opportunity to speak and to treat them respectfully because they're there to reclaim something more than money, then maybe it's not a terrible thing. I mean, I talk 2 chapters in the book about the South African Truth and Reconciliation Commission, ultimately a very un-American concept. In return for granting amnesty to people that committed horrible crimes in South Africa during apartheid. The commission served the purposes of providing an open forum for people to come in an uninterrupted way to speak to what had happened to themselves and their families.
Do you think people felt better because of that?
Absolutely.
Well, what would you react? Let me give you an American point of view. Not to be mistaken, I don't wish to be mistaken as thinking this because I don't know what I think, to be honest about it. What if I were to ask you the following question? Should that have been done with the Holocaust instead of having the Nuremberg tribunals?
Well, interestingly enough, Dean, I think that the Nuremberg Tribunal served that purpose as well. It was intended to serve that purpose. You know, Henry Morgenthau, who had been the Secretary of Treasury during the Roosevelt administration, argued that there shouldn't be any international tribunal, that given the enormity of the crimes...
Yeah, he would have just taken him out and shot him.
He believed in summary executions.
Me too, I'm for Morgenthau.
Right, just saying, why would we possibly go to the trouble and the expense of conducting these elaborate trials? And I think one of the reasons they did is to force the world and Germany to confront the enormity of the crimes, that trials serve a function beyond outside the parties themselves. All of us should learn something. All of us are better off by witnessing judgment. That's why even Sophocles, 500 years before before Christ, Oedipus Rex is a trial. Throughout history, we've seen trials. And remember, in Oedipus Rex, not unlike all Greek tragedies, there's a Greek chorus. The community participates, the community watches. It's important for all of us to be engaged, to participate in judgment, to witness judgment and resolution and justice.
Isn't that why one of the reasons why the Israeli government put Eichmann on trial in
Yes.
1960?
Absolutely. That no country in the world obviously had more of a claim, a right, to shoot him immediately, to kill him and execute him immediately. But the purpose there was for the world to hear what had happened and to give victims yet another opportunity to speak to their loss and the grotesqueness.
Do you think that cases like the O.J. case, and now you can hardly turn on the television now, and maybe this is one reason I don't turn it on, without hearing about the Scott Peterson case. Do you think that these cases that are very much in the news are serving some kind of function of the kind you've been talking about?
Well, on some level, yes. On some level, they function as quasi-entertainment because of the salaciousness of them. There's something about the nature of the proceeding. Look, the proceeding, the openness of the proceeding is always good for a community and for a people. I don't, obviously, from a moral justice perspective, I believe in cameras in the courtroom. I don't think I think the more open, the more that people can participate and witness, the more moral justice is served. On the other hand, I think the choice of what we're showing on television speaks to Q ratings or entertainment value. We could probably do better by opening up our legal system to cases that might really illuminate and enrich us with larger questions about humanity.
I must say that I think that this television program in the jury room is doing that.
Right.
As for no other reason, viz. The very questions that my wife and I have been asking about it in consequence.
Because it's disturbing, and that's not bad. It's precisely that it's disturbing. It gives us a real window into how oftentimes callous judgment is made, how indifferent people can become, and how complicated it is, that it's not that simple.
You know, this is, in a sense, totally off the subject, but isn't there a real sense, Thane, in which you are riding one of my own personal favorite hobby horses? An idea that's not largely accepted in this society, which is that in general, most of the time, secrecy at any level for anything is a very bad thing that leads to bad results and bad actions.
Right, meaning the book is an attack against that.
I think that
Yes,
your point is
absolutely.
an attack against that.
I attack the attorney-client privilege.
Yeah.
I think that the fact that lawyers are turned into purveyors of secrets and lies is not something that lawyers and the legal community should regard with such honor.
Yeah, I want to come back to that because that's a whole story in itself, in which you're the only other lawyer I've ever found who agrees with me. So I will want to get back to that.
I'm proud to be in that company.
What do you think about the Kobe Bryant case in terms of your point that relevant evidence is kept out, evidence that should be brought in is kept out? Does that have any bearing on your
It does. In rape cases, it's just so complicated. On the one hand, given my own thinking about moral justice, the more story, the better. The more truth, the better. On the other hand, one of the reasons we have evidence rules is to prevent prejudice, to make sure that the jury is untainted from information that might lead to have them draw a prejudicial conclusion. The Kobe Bryant case is disturbing because there the mistakes were made by the court. The court itself, it's not even, it was sort of the management of the evidence was ultimately released. But rape shield laws serve a valuable purpose because you want victims to be able to come forward.
Let me put the other side of it to you, Thane. In the Kobe Bryant case, and my colleagues, I think in general, readily, I guess it'd be fair to say you almost rushed to judgment. They agree with what you've just said. So I'm sort of the odd man out here. But the question in the Kobe Bryant case essentially was, as I understood it, was it consensual or was it not consensual? And people say, well, the woman's history of sexual relations or lack of sexual relations has no bearing on this time. Mm-hmm. But they wanted to try to bring out the claim, that she'd had sex with somebody else that same day or very closely to it and then after it. And doesn't this bear, since what you really have is a swearing contest, I say it was consensual, I say it was not consensual, doesn't that really bear on the decision a jury has got to make? And by keeping it out, aren't we loading the dice against Bryant?
I agree. We don't disagree on that. I think that's why I said before, rape is different than other cases. For instance, in the book I talk about, I think it's Rule 404B in evidence rules, and that has to do with other bad acts, prior acts. Most people are surprised to learn in an American courtroom, if you've been convicted of 8 shoplifting offenses, if you're now prosecuted for a shoplifting offense, the evidence rules would exclude any evidence of the prior 8 shopliftings. Now, morally, that sounds weird and twisted because the most interesting fact is that this is a person with a real tendency and a history. The evidence rules, in order to narrow the scope of the inquiry, says that, well, we couldn't let the jury know about the prior 8 shopliftings because they would then have a propensity to infer guilt. On the other hand, again, from the perspective of moral justice, the more story, the better. The more truth, the better, but we really stack the deck against truth. So in that regard, the rape case has similar qualities to the extent to which that a woman would have a sort of long and interesting sexual history. One would say, especially if it was so concurrent or taking place almost simultaneous with the crime, you'd think the jury would want to know it. The problem, of course, is that in rape, which is very different from shoplifting, we want victims to come forward, and to torture them only induces greater pain. And that's the complication of rape, which is why I have conflict about that. On the one hand, I think the more truth, the more evidence, the better. On the other hand, the ultimate truth is to make the case against people who have committed these crimes. And without the witness, without the victim, there isn't any way to do that.
Thane, we have to take a break. We'll be back in 2 minutes. Stay with us for a continuation of our interview with Thane Rosenbaum.
Integrity first. Service before self. Excellence in all we do. These are not just words. These are our core values. Values by which each and every member of the Air Force Reserve lives. So whether we are deploying humanitarian aid, or providing natural disaster relief, or defending freedom wherever it's threatened, the men and women of the Air Force Reserve are there, protecting our values and serving our country. Air Force Reserve, above and beyond.
There is strength in our numbers. Our call is to action, to practice what we preach. Be there to care. Our passion is compassion. We're only human, but together we're humane. Our letters stand for taking a stand, for taking the lead, for filling the need. the American Society for Prevention of Cruelty to Animals. Be part of our heart.
Exercise your emotions. Attend a live orchestra concert. Go to findaconcert.com.
Welcome back. Thane, when I read books like yours that have concepts that I'm not really sure I grasp, I try to reduce them to something that my simple mind can understand. So I want to try something on you and see whether you agree with it. When you say there's no morality in law, or little morality in law, there's a strong, an overwhelming sense, isn't there, in which what you are really saying is the law doesn't seek the truth, and there is no, and it is only to seek the truth that makes you moral. Is that a fair description of a pretty fair amount of what you're saying?
Well, when I say that there's no morality in the law, is that what I'm essentially saying is there's a big difference between justice and what's just. Justice is the administrative operation of the law. Justice is what you get from the law. But that doesn't mean it's just.
Well, why do you
There's
use
a
that
difference.
word? You see, I mean, that confuses people like me, because what you're saying, you're using a word that's normally used to mean one thing, and apparently you're using it in quite a different sense. You're just saying, well, this is the way the law operates. In a philosophical sense, this is not justice, it is the way the law operates.
Well, that's why people say there's no justice. That's what they mean. When people scream at the heavens and say there's no justice, what they're really saying is what we believe the courts do, which is to provide a resolution that will emotionally and morally feel just to us, is not what we received.
And so what you're saying, again, it's a question.
Right.
You are saying, aren't you, that people are looking to the courts for resolutions that they can believe are fair and honest and reflect the totality of what occurred.
And wise and factual and true. Exactly. That makes sense to the heart, to the mind, that people walk away without shaking their heads. And that they say, there's wisdom and justice in that resolution. There is kindness and humanity in it. How many people walk away from an American courtroom saying, son of a gun, there is wisdom in that resolution, there's kindness and heart and tenderness and a real sense of completion. It's laughable. Nobody would say that. And the answer is, that's because justice has nothing to do with moral outcomes. It has to do with achieving the correct legal result. The public doesn't understand that.
But how can the correct legal result be a result that is not, in the terms I used before, that does not seem correct, fair, and reflective of the total circumstances?
Right.
Well, it can't, can it?
Happens all the time. It happens all the time in part because the remedies are not there to provide real relief. They're simply there to cut a check or to put somebody in jail. But ultimately, it doesn't make sense. It doesn't feel as if there's any true sense of closure. There's no opportunity for apologies. I mean, I spend several chapters in the book talking about the lack of apologetic discourse in the American legal system. Basic moral decency. The very basic idea that the truth matters, that dignity matters, that apologies matter. Those are the language of the moral universe, and that's not what the law provides.
Are you saying that people expect that when someone comes to court, the person will be able to fully tell their story, to get it across, and that by doing that, the sense of grievance will be ameliorated?
I think they don't, even if they don't realize it, that's internally what will make them have that sense of closure. This is why people walk away constantly saying, that was it. Saying, I never got a chance to say what I came there to say. And that
Excluded, not credible,
irrelevant, immaterial. Think about these words.
These are the key words in
Dismissed.
your judgment that affect what people think about the law because they control what goes on in a courtroom.
Dismissed. I think this is an outrageous word. It shows no virtue. The use of the word dismissal, how often it's used by lawyers, such an incredibly arrogant word. The dismissal, endless motions to dismiss. Everything is about dismissing grievance, dismissing emotion, dismissing subjectivity, dismissing just the sheer awe of what it takes to come before the community seeking resolution, seeking fairness. And that idea is completely missed in the conventional legal paradigm. And I believe that most people come to the legal system surprised that that sense of truth, that they thought that there would be a historical record created, so there would be an expression of truth that would be preserved for history, and that would be an opportunity to encounter those who have harmed them or betrayed them or breached their promises, and that there would be a resolution that makes sense. I think most people believe in good faith that the law can do that, and it doesn't.
It gives a new meaning to the word dis, doesn't it?
In the book, Dean, I say motion to dismiss is the ultimate dis.
You make a big, what if the law, well, a couple of points. Lawyers would say, wouldn't they, you cannot have a judicial system along the lines you suggest because, well, we would have to have 100 times more lawyers in courts.
Right. But that question is asked as if that's a bad thing. Look, there's a blank check when it comes to the national health of our national defense health of our nation. Nobody ever questions about how much smart bombs cost or how much weapons defense missiles cost. Nobody even, we assume that when it comes to our national physical defense, that there is no budget constraint. But when it comes to our spiritual defense, our spiritual health of the nation, which in many ways is determined by the resolution of our conflicts, there we have a completely inelastic budget.
Thane, tell me something. Suppose that well, no, let me rephrase this. I would, for purposes of argument, and I don't quite really believe what I'm about to say, but for purposes of argument, I might suggest that if you gave somebody an opportunity to tell his or her full story in court,
right,
and then, of course, both as a witness and by bringing on other witnesses who are examined and with documents and so on, and then that person were confronted by someone else on the other side who does the same thing.
right,
And if at the end of that case somebody were to win or lose, it's not unreasonable, is it, to suggest that the loser is going to be just as mad, just as disappointed, and just as unhappy with the system as losers are today?
Look, it depends on the way the trial is conducted. Generally speaking, I would say even in the way you framed it, I think they would walk away feeling a lot better knowing that they had a true day in court. They still lost. The jury didn't see it their way. They didn't get the break, but they had an opportunity to be heard, a true day where they were heard, where they were not interrupted, where their witnesses were also heard, where the evidence that they were able to provide was offered, that they would ultimately feel that they had an opportunity to speak. But in addition to that, one of the attacks that I make in the book against the legal system is that the legal system, in its winner-take-all philosophy, in its adversarial game contest of sort of a sporting theory of justice, is only interested in retribution rather than repair. So what I would say that if judges were interested in giving people a full day in court and then finding a way to try to resolve the conflict in a way that was more restorative than retributive, the sense of thinking about law as a healing profession, thinking about it in ways that are not merely about rough justice, but finding a way to provide restoring moral balance to relationships. How can we restore, repair what once existed? It's not enough merely to assign liability. What other things can we do to make people feel reconciled to this resolution. We don't do that. So I would say it's two things. One, give them the full day, give them an opportunity. I would still say, Dean, that they would feel better with that even if they lost. But don't make them walk away as if it's lost. Give them a sense that there's some attempt to reclaim dignity and to restore moral balance to relationships.
Let me go back to the fact that they would lose. You see, I actually happen to agree with you that if I drop my pose of just making the argument, I actually happen to agree with you that
they'd feel better anyway.
They'd feel better anyway. And I'm wondering, Thane, this is a little off your subject, but isn't that one of the fundamental things wrong with our political life in this country today, which is that so many people feel they simply cannot be and will not be heard?
Right.
And that if people feel they are heard and what they consider a fair decision maker decides the other way, well, so be it.
Mm-hmm.
And that leads to another question. I mean, one question leads to another. What about people who, take the abolitionists? They kept going to court, and the judge would listen to, back in the 1830s and 1840s. The judge would listen to them, and the great lawyer, Salmon Chase, people became nationally famous. And they'd lose, and they'd lose, and they'd lose, and they'd lose. I mean, after a while, isn't it true that even a fair chance to be heard gets to be a little old when you never win?
Except that if you believe, again, it's a very American concept to see it in a kind of immediate win-loss context. But from a moral justice perspective, change is incremental. Transformation takes time. That we would look upon, from a moral justice perspective, we would look about abolition, even the civil rights movement. All of those cases, even despite the mounting losses, paved the way for a transformation. That there was value in that. That the more juries were exposed to this, the more the media picked up on this, the more we had opportunities to speak in a socially activist way to the injustice of slavery and the injustice of post-Reconstructionist racism in the South, the more one could envision transformation. Again, if you can see it in incremental terms, you could say repeated days in court, even with no success, will ultimately lead to a renewed spirit of transformation in the future.
You know, we had, one of my last interviews was with Jules Lobel. Mm-hmm. Have you read his book?
No, I haven't, but I know.
He says, he's written a book saying exactly that.
Great.
I think it's called Winning or Success Without Victory. Mm-hmm. And it's about people who fought the good fight, fundamentally because they wanted to keep the issue in the public arena.
Isn't that what we mean by a test case?
Yeah.
I mean, that's what we mean. We test it, we float it.
Yeah.
We think we can continue to bring it out until we find courageous judges who are capable of thinking outside the box, not worrying so much about stare decisis, and saying sometimes moral authority supersedes legal authority.
Why do you think, Thane, that the judges themselves are so convinced of their own objectivity when, as I understand it from your book, they are anything but objective? And
right.
Of course, most lawyers and law professors would agree with you.
Right. Well, I think this is the problem of thinking of the legal system as a science rather than an art and something that is ultimately human. You know, this idea of blind justice is absurd. Judges have biases. There's nothing objective about it. They have predispositions. They have faces they like and faces they don't like. If some of your background is something they like, they don't like the color of your skin, they oftentimes will one side to win just by...
You make that point about the two people who are, I don't know how you pronounce bête noire, but who are bête noires, the liberals, William Rehnquist and Judge Clarence Thomas. Why don't you explain what you think about what they did in a couple of cases?
Well, I mean, we're trained to think of lawyers, or we're asked to think of lawyers and judges as being without emotion, without subjectivity, without any passion, that they're purely detached, unemotional, and removed. But oftentimes when you can expose judges to this, you start to see, most recently in, was it Virginia versus Black last year, the cross-burning case. It's fascinating with Justice Thomas, who is notorious for never speaking an oral argument. He never asks any questions. But in Virginia versus Black last term, the case that involved a cross-burning on an African-American family's lawn, he immediately started to talk about the pernicious impact that these symbols of racism have had on the African-American community. Eight of his brethren were shocked to hear him speak, but if you think about it, many people in the bar were opposed that Justice Thomas would enter into the conversation speaking from personal experience. That's not supposed to be appropriate. Ironically, the rest of the judges chimed in and also weighed in about the legacy of racism and how it ties into cross-burning. And ultimately, the case was decided in favor of Virginia in the way that they tailored that statute to prohibit that
So
kind
they
of...
could prevent cross-burning, which is regarded by a lot of people as a form of symbolic speech. But if you burn an American flag, then what?
Well, again, you know, very different, and maybe not, depending upon how patriotic you are, right? I mean, you know,
What does the Supreme Court feel about that, if anything?
well, we haven't gotten there. We don't know. We don't know we don't know what Virginia versus Black now does to flag burning. We don't know what Virginia versus Black would have done now to Collins versus Smith. You remember that was the case of the neo-Nazis marching in your own Illinois.
Yeah.
We don't know what that case would have done because there again, and I talk about this in the book, that we're not sensitive in a moral context to spiritual violence. We're so focused on free speech that we're not willing to accept the re-traumatization of people and the spiritual harm that's caused by allowing people to invoke their free speech rights without calling attention to the fact that they're causing harm in a spiritual sense, even if not in a physical sense.
We'll come back to that right after another brief break for another announcement. Stay with us. We'll be right back.
Hi, Jeff. No, I'm still at the train station. I just almost got killed. Yeah, about 10 minutes ago. I'm still shaking. Well, I got off the 940 and Jill called. Yeah, it was raining, and so I put the newspaper over my head. I forgot my umbrella, and I didn't want to go walk over the overpass. And then I heard the whistle and the light. I was walking right into a train. This guy, he pulled me back.
Look, listen, and live, or someone you love will get hurt.
I just almost died.
How far would you go to help someone? Would you go to the end of your driveway? Would you cross a street? Would you cross an ocean? To a place 6,000 miles from home? And how long would you go? Would you go for a week? A month? A year? Would you go for 2 years? Would you go if you could use your knowledge to teach someone, and in the process, maybe learn something yourself? Life is calling. How far will you go? Peace Corps.
Welcome back. Thane, talk a little bit more, if you would, about the law's failure to understand that a lot of times the harm that has to be rectified is in here. It's in the heart.
Right.
And the law focuses on money, but sometimes money isn't the be-all and the end-all. Sometimes it's not even the most important thing, but it's all that the law considers.
Absolutely. You know, if you remember in Shakespeare's Othello, Dean, nothing that evil Iago does is actionable under the law, certainly not in an American court of law. I mean, he causes all this death, but because nobody is physically scarred by his hands, there's no physical bruise, there's no actual blood that he is responsible for in a legal sense. This speaks to, again, this problem in the American legal system and its failure to account for spiritual violence, spiritual injury, spiritual indignity and disrespect, shame, humiliation, debasement, We live, oddly enough, in a legal system that is based on a nursery rhyme, the idea that sticks and stones can break our bones, but names cannot hurt us. Anybody that's ever been subjected to humiliation and indignity and disrespect will tell you that's absurd. Even victims of spousal abuse sometimes say that they're happy when the punch takes place because then it'll end the verbal abuse to which they've been exposed. Many people, it's such a huge part of our humanity, the idea of our interior, our internal life. But the legal system only becomes animated and interested if the body is harmed. And so there's many examples.
The legal system pays no attention. And largely you are right. There are some exceptions, but in the vast main, you are
But
right.
even for people who think that emotional distress covers this, it doesn't cover it because it only happens after you have a physical injury. It's rare that you'd ever see emotional distress being awarded without some physical injury that it could attach itself onto.
Why does the law take this position that there has to be, in general, take the position that there has to be a physical injury?
I think because we're willing to suspend our disbelief on the physical side, but when
Even though we know that people are faking it a lot of times.
people come in all the time with neck braces, they're lying. There's all kinds of uncertainty and ambiguity about injuries in the physical realm, but we tolerate the ambiguity when it comes to the body. It's very odd. In the legal system, the body is the object and obsession of the law's focus. Nothing happens unless the body is injured or harmed or money is taken or property is taken. But the idea of spiritual violence is something we completely reject, perhaps on the idea that you suggest, that we believe that people will fake spiritual violence. But what I tell my students all the time is that if you put Iago on trial and prosecuted him, and if Othello had not killed himself and was able to testify, I think juries would understand that what this element of sabotage, mind games, manipulation, this kind of spiritual violence is injurious and should also be actionable under the law.
What do you think about, in that particular light, what do you think about the kinds of speech codes that were popular on so many American campuses in recent years?
Look, again, I think words can harm. I think that we should be worried about this idea of free speech, unfettered free speech, without any recognition that it causes harm. Again, it's different. There's a difference between opening up the marketplace of ideas so that ideas have a place to be expressed. That's where I'm in complete agreement with free speech absolutists. I don't agree that ideas can be communicated in such a way that re-traumatizes already victimized people. I think that the idea of separating the idea itself from the violence that's done to someone's spirit is something that the law should take more seriously.
Well, let me ask this. Take this case in Skokie, for example.
Yes, good example.
Which was where the Nazis marched in a heavily, the town was not only heavily Jewish, there were many, many survivors of the Holocaust.
Predominantly Holocaust survivors.
No, that's probably true. My parents lived there, but they were not Holocaust survivors.
But I bet many of their friends were.
Yeah, well, some, yeah. Okay, be that as it may. The Nazi Party got the opportunity through the courts to march in Skokie. Now, would you say, A, they shouldn't have been permitted to march? I assume you would say that. And B, would you say they should not be permitted to present their view anywhere at any time?
No, I think the view is separate from the idea of goose-stepping in brown shirts into a small town populated by Holocaust survivors. That's different. Nobody's talking about censuring the idea. Again, Virginia versus Black. There's the idea of saying that you have difficulties with government programs that subsidize African Americans, or that you're a racist on some level. But burning a cross on an African American's lawn is an incredibly pernicious symbol of violence. It is an act of violence, and the idea that we don't see it as a violent act because the body is not harmed seems strange to me and immoral.
You know, particularly it's 50, 60, 70 years now that we've had the doctrine of fighting words, which means some things can be said that are so likely to cause somebody to take a punch at you that you can be restricted from saying
But think about that, Dean. Think about what the emphasis of that language is. It's not on the fact that you could harm someone spiritually. It's that he might retaliate and harm you. The focus is on more bodily injury. The law is endlessly obsessed with the body. It's worried about the retaliatory strike. It's not worried about the damage that's done to the person's feelings.
That's true.
And it's an interesting thing. Even when we try to do it, we don't do it for the right reason.
I always assumed that the reason for it was the emotional injury would cause somebody to strike at you, which would cause, you know, the warfare back and forth. But that is different.
There's a different distinction. Yeah. It's saying if it's so likely to cause a retaliation, then they're prescribable words that can't be invoked.
Yeah.
Not because they could cause harm to you spiritually, but because it might incite you to violence.
Yeah. Thane, you often talk about apologies as a potential remedy that is overlooked by the law.
Right.
Why don't you elaborate upon that a little bit?
Look, we tell our children, apologize and say it like you mean it, right? We do this all the time, but our courts never ask people to do this. We have no expectation. In fact, there are disincentives in the law through evidence rules, again.
By the way, excuse me for a moment, Kobe Bryant just issued what I take it you would call a pseudo non-apology apology as part of the settlement.
Although better than most people, still, given our American tendencies to apologize at no cost, under no circumstances. At least there is an apology, but you're right. In the book, I would call that a passive-aggressive apology, not an apology that is sincerely offered, an acceptance of responsibility, and an effort to truly seek to make repair.
Nixonian.
Right, exactly. Nixonian, or Bob Packwood. I apologize for what it was alleged that I have done. You know, that's the American way of apologizing. A true apology is where a person accepts responsibility, is sincerely and contrite, and seeks to make amends, to try to find some way to repair, a true acceptance of responsibility. That is morally necessary, and the legal system completely makes it impossible to do that by deeming it statements against interests, admissions of guilt, when in fact what we really want are parties to come together to encounter each other and to hear each other in such a way that the party that has been injured can hear true apologetic language, sincerely uttered. And as I point out in the book, that takes the insult out of the injury. This is not a replacement for compensation. A check should be written to compensate to the extent to which there is material harm. But there's still a moral component that has been unfulfilled, which is the other party expressing remorse.
Why don't you comment on two things that are perhaps interrelated? Certainly they're coincidental. Why we don't have that in the American legal system, and why, for example, nations like Japan do have